Everyone see that it's begun recording? Okay. Good morning. This is an evidentiary hearing in case number 23-3961-PET, which concerns the petition of Morrisville Water and Light Department and the Village of Johnson Water and Light Department to condemn easement rights in property interests of William and Lesley Adams for an existing electric transmission line pursuant to 30 V.S.A. section 111A. My name is Jake Marin. I'm Deputy General Counsel of the Vermont Public Utility Commission, and I have been appointed to serve as hearing officer in this case. Wes Skidmore, an attorney with the Commission, will also be participating in today's hearing. There may be a few Commission staff members observing today's proceedings for training purposes. To begin with, I'll start by taking appearances. I'll begin with the petitioners, followed by the Adams, and then the department, and then any other party who's participating today.
Good morning. Brian Long on behalf of petitioners.
Mr. Simons? Is he on yet?
I know that when the recording was started, something pops up that you have to click on. Oh, there it is.
Yeah. Okay.
Can you hear me now?
Yes.
Yeah. Bryce Simon on behalf of William and Lesley Adams. Thank you.
Thank you. Mr. Swain?
I'm Michael Swain on behalf of the Vermont Department of Public Service.
All right. Are there any other parties participating today? Okay. I'm going to begin today's hearing by reading a few instructions for remote hearings with the Commission, and after that, we'll get to the substantive portion of today's hearing. As an initial matter, please raise any concerns at any time if Teams is not performing as you expect, or if you're having difficulties with the platform. And you can do that by speaking up or raising your hand or putting something in the chat. Representatives in this case should keep their cameras on during the entire hearing, except during breaks. Witnesses should leave their cameras off until they are testifying, at which time they should turn them on. Even with your camera off, you will still be able to see everyone who has their cameras turned on. My preference is that people who are not parties to the proceeding leave their cameras off so that the pictures of the parties and active participants are larger on the screen and easier to follow. I will not mute anyone's microphone, whether a party, a participant, or a member of the public. This means you need to keep yourself on mute unless you are speaking. During breaks in the hearing, I ask that all parties and participants turn off their cameras and mute their microphones. When you begin speaking, please identify yourself by name for the record. If your internet connection cuts out at any time, please try to rejoin the meeting or call in using the Teams telephone number and password that were provided in the meeting notice. I will share on my screen right now that information. Can everyone see that and read it? Do you need me to make it larger? Okay. If audio or video from the hearing cuts out for you, please let me know when you are able to rejoin, and I will summarize what has happened, and we will revisit any questions on which an objection may have been allowed, including in the admission of an exhibit. If you are unable to call in or rejoin, please notify the clerk's office immediately via email or via telephone, and we will pause the hearing as necessary until the issue is resolved. If it cannot be resolved, we may need to reschedule the hearing. Similarly, if at any point you become aware of another party or participant or member or participant having trouble using the video or audio feeds in this remote hearing, please let us know immediately. We may pause the hearing as necessary until the issue is resolved. During the course of this hearing, if you have an objection, you must raise it at the moment the objection rises. When objections or issues are raised, I will ask each representative one by one whether they have a response. Please wait until I call on you to respond and then answer verbally so we have your response on the record. When you were asking questions of witnesses, I don't know if I need to actually make you a presenter in Teams. Sometimes the platform has sort of special designations, but I believe everyone right now has the permissions to share their screen. When it is your appropriate time for you to be sharing documents, I ask that you do so. Alternatively, if someone else is working with you, they can show the document. So if Mr. Johnstone or another witness has the exhibit handy and they can share it with their screen, it doesn't matter whether it's the representative or the other participant. That's fine by me. The questioner must wait to ask questions about a document until after the document is visible on the screen. Please verbally identify the document you are showing for the record. For example, clearly showing, I'm showing Department Cross Exhibit 1. When you're done with the document, please click Stop Sharing Screen. Whenever you are sharing your screen, I advise you to close out any unnecessary applications, such as email, to avoid notifications being visible to others during the hearing. Does anyone have any questions or concerns about these procedures? Okay, with that covered, we'll now begin the substantive portion of today's hearing. Before we get to the cross-examination of witnesses, I understand that Mr. Simons has an objection that he'd like to note on the record, so I'll ask that you do that now, sir. Unfortunately, we can't hear you, sir. And still muted.
So this mic's not working. How about now?
Now I can hear you, yes.
All right. And what's that? Hold on. How's that?
Nice and loud.
All right, and not echoing now. So before I start with the substantive issue, just another procedural issue real quick. Is it okay if I use a automated note taker?
I have no objection to that. Any other parties have an objection? We're transcribing this whole meeting right now, so but if you'd like to have your own copy, that's fine by me.
All right, thank you. And then, so the substantive issue I just wanted to raise, and thank you for the opportunity, is a threshold question. It could be viewed as a motion to dismiss under Rule 2.206 on what are analogous to subject matter jurisdiction grounds. And I know that you don't follow the rules of civil procedure, but there's no good analog in the PUC rules for Rule 12 motion relative to subject matter jurisdiction. Typically, those can be raised at any time. And it took us a while to get our heads around this issue and to also do the research necessary to make sure that we weren't raising the issue without adequate basis. But it's a two-part issue having to do with whether or not the petitioners have authority to proceed under 111A. First of all, we would want to submit that the petitioners do not have independent rights to condemn property in other towns. So both petitioners, Morrisville and Johnson, operate municipal plants. They're seeking to condemn private land in the town of Stowe. 111A does not itself expand municipal power. It assumes legal authority under Chapter 79 of a entity that's authorized to condemn. And so the authority to condemn outside their own municipalities would have to come from the statute, and the record contains no order or statute authorizing either municipal petitioner to condemn the Adams property in Stowe. Second, petitioners have not proved the required PUC approval under 30 V.S.A. section 2913. That section requires commission authorization after notice and hearing before a municipal plant may extend its mains or lines into an adjoining municipality. Petitioners produced no section 2913 order. We've looked through the archives. We've not been able to find any, which would typically be required to extend for Morrisville to extend its municipal plant into Stowe, and certainly for Johnson to do so. The project is alleged to have been constructed in 1949 or later, and so therefore section 2913 applies as it was enacted in 1941. And this is not a factual dispute. We view this as a capacity, a threshold issue because of the fact that there are municipalities in extraterritorial condemnations. And so we do submit the petition should be dismissed. under Rule 2.103, but also understand that if the hearing officer believes that it's important to take testimony, we believe we want to reserve the right to make this argument based on the factual record, and specifically we want to have the opportunity within the factual record to make a record of there being no such authority. Thank you.
Okay, I'm not going to ask for a response from the petitioners right now. This is obviously some pretty substantive legal arguments. Mr. Simons, you're going to have to brief it for me. But we are going to go forward with creating the evidentiary record today. I think it's necessary to come to a some resolution of all the issues. But yes, feel free to raise this in your brief, and I expect that the petitioners will be able to respond in their briefs, and that should be sufficient to deal with those issues.
Yeah, we'll do that, Your Honor, and we'll certainly address it in the briefs. And we just want to make clear at the outset that we're not waiving the issue. Ms. Adams wants to indicate she's participating under protest, given what she's learned about those issues.
Understood. Sorry, I just noticed that my phone's ringer was on, which is, good advice to all of it. Turn your cell phone ringers off if they are currently on. So I apologize if that disrupted anyone. All right, so we're going to move on to the admission creating the record here. I will note on the record that the pre-filed testimony and exhibits that were identified in attachment A of my order dated June 4th, 2026 have already been admitted. If any party wants to offer a cross exhibit during this hearing, they need to do so during the course of their cross-examination. So we're going to begin the cross-examination, beginning with the witnesses of the petitioner, and then we'll move on to the Adams witnesses. So without further ado, I'll ask the petitioners to call their first witness.
Thank you, hearing officer. I intend to raise the objection we discussed before this meeting for the purpose of preservation. Yeah. And I can do it either right now, or I can do it after we call Mr. Johnstone, whichever way.
We've already raised the issue. Let's just go on to it.
So for those purposes, Morrisville Water and Light objects to the Adams 2 sets of proposed cross exhibits, one filed on June 12th and one on June 15th. I believe the intent is only to use the June 15th exhibits today to be helpful to confirm that on the record. The basis of the objection is that the June 12th exhibits and June 15th exhibits were filed either late and or not according to form under PUC Rule 2.204. And I believe that relates to filing as a single PDF, filing over the size limit, filing without proper labeling, issues to that kind. And I raise that now for preservation purposes.
Okay, but actually, I'll since we're getting this on the record, I would like a response from the Simons on the record, because actually my understanding is the opposite, that I'll be looking at the June 12th individual exhibits and not this compilation filed on the 15th. So if you can respond to that and clarify what it is you plan, which documents you plan on using in your cross, that would be helpful.
Yes, certainly. And again, I do apologize for the confusion, and I would again just submit, as I did off the record, that there's no prejudice to the petitioners. That these are all either public documents or documents they produced in their own discovery for the most part. But just to be clear about the sequencing, there were some individual exhibits that were filed on Friday, June 12th, prior to 4:30. There were some compilations of exhibits filed after 4:30 on June 12th in an effort to get those to the parties. And then over the weekend, a number of individual additional exhibits were filed, which were all also included in those larger compilations. And again, I've really significantly limited the number of those exhibits that I intend to use as cross exhibits. Most of what I'll be using for cross examination is already entered into the record, and the ones that I'll be using as marked exhibits are, for the most part, either documents that were previously submitted one way or the other, and it's just more convenient to have them as a cross exhibit, There are two documents that I thought Mr. Long said he was not objecting to, which are just pictures of the project area. And so I would encourage the hearing officer to address these individually as they come up, because I think it's going to be a much smaller group of documents we're actually talking about than the number of documents that were filed either before 4:30 on June 12th or after that.
Yeah, I'm going to take you up on that offer, but mostly because I think it's rather confusing to talk about this when we're talking about broad classifications of documents or documents filed on certain dates. What I ask Mr. Simons is that when you do introduce a cross exhibit, to be very explicit about which one you are introducing, and then share it on your screen so that we can all see it, and then I will entertain objections to each one as we get to them. But I'm ruling this way based primarily on your representation that this is a much more limited universe of documents than the entire list that you've presented. So with that out of the way, let's get started and start calling the witnesses.
Just to wrap that up, just to be clear, you're overruling the objection, correct?
At this time, yes.
Thank you.
I'm not going to strike anything at this point. I want to thank you for clarifying.
Okay, petitioners would like to call Scott Johnstone. Mr. Johnstone, could you please turn on your camera? Okay, and I see before me someone who appears to be Mr. Johnstone. Could you please confirm your identity?
Hold on one second. Let's swear him in before we start asking him questions. Yeah, yep. Mr. Johnstone, could you raise your right hand, please? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Thank you very much. All right, you may proceed, Mr. Long.
Are you Mr. Johnstone?
I'm well. How are you?
I'm all right. And can you confirm that you're Mr. Johnstone?
Oh, sorry, I didn't hear you correctly. Yes, I am Scott Johnstone.
And Mr. Johnstone, I'm going to go through a couple of things one at a time. First, did you file pre-filed direct testimony on or about November 15th, 2023 in this case?
Yes.
Did you file pre-filed rebuttal testimony on or about June 14th, 2024 in this case?
Yes.
And did you file supplemental pre-filed direct testimony on or about October 18th, 2024 in this case?
Yes.
And did you file a second supplemental pre-filed direct testimony on or about June 9th, 2025 in this case?
Yes.
And Mr. Johnstone, is that your testimony?
Yes, sir, it is.
Hearing officer, I'm happy to turn over Mr. Johnstone unless there's further foundation you'd like.
No, that's adequate. And I will have a few questions for Mr. Johnstone before we get to the other parties. So I am going to start, Mr. Johnstone, by referring to exhibit petitioner SJ-Sup1, which.
Oh no, we lost the hearing officer.
I will reach out to the hearing officer. Oh, looks like he's back.
Many apologies. They put the share button right next to the leave button, which is very unfortunate for those of us who are not skilled video game players. I have a clicky hand. All right, I'm going to try to share again now without leaving the meeting. All right, can you see what's labeled as exhibit petitioner SJ-Sup1?
Yes.
Do you need me to make it any larger? Are you having trouble reading it?
I cannot read it as it is.
Okay, I'm going to try to zoom in as best I can. And
That's
just
perfect.
go. Okay. My primary question here is about this language that was proposed right here. It states an area shall be kept clear up to 6 feet from the exposed edges of all above ground structures to provide for the continued operation, maintenance, or replacement of said facilities. When this refers to above ground structures, these are utility structures, correct?
Correct.
And the structures in this case would just be the two poles that are on the property. Is that correct?
the two poles and the cross arms.
And the cross arms, yes. Okay. So if I'm going to now switch to a different document, if I can.
I should add in the wires as well, of course.
Well, okay, so would that mean that nothing can be within? I'm having a little difficulty interpreting how I would apply 6 feet from the exposed edge of a conductor. That means, I guess, up in the air, 6 feet. Like I can't have
Correct.
anything within 6 feet. Okay, that's how I would interpret that. Okay, that's helpful. But it doesn't mean you think that the landowners couldn't have things under the wires, provided they didn't extend up to within 6 feet of
That's
the wires.
correct, and that's frequently the case.
Okay. So now I'm going to turn to the map that the petitioner has provided. This is exhibit petitioner SJ-2-SUP1. So when I zoom in on this and I'm looking at the above ground structures that we're talking about here, the line and the poles.
Yep.
Does the company have any concern about this this retaining wall that runs alongside parallel to the line for a period? Is there a conflict there between the easement you've proposed and this existing retaining wall?
We're not concerned with the retaining wall in its current position, so long as we can have access, because then we can reach the necessary component parts from the other side of it. That above that wall, it continues to go up in elevation. So we, other than reaching very far from the south, from the southerly direction, from a parking lot, we can't reach that line anyway. So we would maintain it from the driveway side to
Okay.
maintain.
All right, and then my last question is on this site plan here. You've marked several trees. I understand, and correct me if I'm wrong, my read of the easement is that you would have the right to clear any of those trees, but your proposal is to not necessarily clear all those trees. Can you either clarify that or provide any more detail to what the company's plans are for the vegetation that's shown on this plan?
Yeah, so for any vegetation, we try to only impact that which we need to maintain the line. So, of course, like all utilities, a clear right of way is the best right. A clear right of way is the best right of way. But when you get into an urban area like Stowe, this part of Stowe, we become much more careful about what we cut. So if a tree is dead, or if a tree has the opportunity to be up into the wires, even under a heavy snow load, then we try to cut what we need to maintain electric service. And we try to be as discreet as we can about how far we go with that.
But my understanding basically is that while you have this right, you use professional judgment to decide when it's actually necessary to clear a tree.
That's correct, and we usually, where we can with property owners, we talk it over with them and find out what's important to them and do as well as we can by them and with them.
But ultimately, the decision rests with the company as to what's necessary to maintain the safe operation of the line.
Yes, it has to, as we have responsibility with the sub-transmission line to the whole region of Vermont.
Okay. Wes, do you have any other questions for Mr. Johnstone? Johnstone?
I don't think so. Thanks.
Okay, I don't have any other questions. So at this point, I'll ask Mr. Long, do you have any redirect based on my questioning?
Not at this time. I believe we'll discuss a little bit about the fence later on, property boundaries, things like that, but we can deal with that later.
Okay. Then, Mr. Simons, you can begin your cross-examination, and I will stop sharing my screen. All right.
Thank you, Mr. Hearing Officer. And just, sorry, we have multiple machines here, and I'm just trying to make sure that you can hear me. And just, I honestly don't care, but my name is Simon, not Simons. But
Oh, I apologize.
Just want to let you know that. All right, Mr. Johnstone, you and I have met before, haven't we?
Yes, we have.
All right, good morning. You're the general manager of Morrisville Water and Light Department, correct?
I am.
And you became general manager in or around June 2022, correct?
That's correct.
And is general manager the only position you've held at Morrisville Water and Light?
I'm also the manager of the village of Morrisville, in addition to being the general manager of Morrisville Water and Light.
And have you previously held any other positions there?
No, sir.
And in which year did you begin employment with Morrisville Water and Light?
I'm sorry, I didn't understand you. It was garbled.
Was it June 22? Was that your first year working for Morrisville Water and Light?
That's correct.
And as general manager, do both the line superintendent and the plant superintendent report directly to you?
That's correct.
And can you state the names of the individuals who are serving those two roles right now?
Right now, the two individuals, Thad Shed, he goes by Rusty, is currently the electric superintendent, in charge of this operation. Our plant superintendent is Kevin Newton. The plant superintendent is not involved in the transmission and distribution system.
All right, thank you. And David Heller, he retired from Morrisville Water and Light in December 2024, correct?
Around that time, I couldn't tell you for sure, but I believe that's true.
He's no longer with the village, correct?
That's not correct. He's a part-time employee. He retired from full-time status, and he's a part-time employee of Morrisville Water and Light.
All right, so he's no longer line superintendent or plant superintendent, though?
That's correct.
But you said he's a part-time employee?
Correct.
And what's his title?
He's been working on special projects for us of various types.
And your professional background is in civil engineering, correct?
Yep, I'm trained as a civil engineer.
You're not trained as an electrical engineer?
Nope, absolutely not.
Could you look at it with me, and I'll share my screen here. Hopefully bear with me. I had to restart the computer to make this work, and so hoping this works. All right, so I'm looking at the original petition. Oh, no, I'm not. Hold on. I'm looking at the original petition for condemnation in this matter. Do you recognize that?
I can't see the top of it, so, but yes, I see the words there, yes.
And that was filed solely by Morrisville Water and Light, correct?
That's correct.
And that original petition, well, strike that. There's no established deeded right-of-way over the Adams' property, correct?
Not that we can document. There's a lot of records, but nothing that was filed in the land records that we can document.
All right. Thank you. And petitioners are not able to obtain prescriptive rights pursuant to 30 V.S.A. 2519, correct?
I don't know the statute, so I can't say that, sir.
Yeah, sorry, I couldn't get to the mic fast enough, but objection, he's asking for a legal opinion.
He said he doesn't know, so I don't know if you want to strike that answer. Or?
I'm fine with keeping the I don't know. That's fine. But let us try to avoid asking the witnesses for interpretations of statutes or things like that.
The petition and then later the amended petition were filed to secure a legal right of way over the Adams' property, correct?
Objection, largely for the same reasons.
I mean, I can rephrase it, but his own testimony essentially says that. But I can rephrase it, just ask, don't you believe that the reason for the petition being filed was so that Morrisville Water and Light could obtain a legal right of way over the Adams' property?
I believe what we asked for was an easement, not a right of way. I believe there's a distinction between the two. but I'm not certain about that.
If we look at the document that is up on the screen now, it is exhibit PETSJ sub 1, the Village of Morrisville Water and Light Department. The document that you're requesting be allowed here is titled right-of-way easement, correct?
That's correct.
Presently, Morrisville Water and Light has only 2 poles and an overhead 34.5 kilovolt power line with associated components on the Adams property, correct?
Yes, sir.
There's a little bit of lag. I apologize for that. And the prior filing, sorry, strike that. Prior to filing the petition, there was no state, well, strike that. Prior to filing the petition, you're not aware of any basis for legal rights to keep those power lines that are on the Adams property in their current location, correct?
Objection asks for a legal opinion.
Response?
He's already testified that the lines were being operated with state authority.
I think there's a
Not
rule.
like that. See, not testified. I shouldn't have used the word testified. He's provided discovery responses that make that claim. That I can, my intent is to impeach him if he denies it, but I think it's appropriate for me to answer the question given that they've already answered in discovery.
I guess I'm gonna uphold the objection here though, because the petition states what kind of relief they're requesting here, and I don't think there's any need to really elicit a lot of testimony about that. You can cite the petition in your brief if there's either a legal deficiency or some statutory limitation on the rights that the petitioners are seeking. But I don't think testimony is going to really inform this analysis for the commission. We're going to be looking at the statute. And we're going to be looking at what relief the petitioners have requested in their petition. So I'm going to ask you to move on at this point because I just don't see how this is going to inform us in any helpful way.
All right, I'm going to make a proffer that and what I'd like to ask is, Mr. Johnson, didn't Morrisville Water and Light state in response to the Adams's information requests that Morrisville Water and Light has a right under state law to maintain its line in its current location? And I direct your attention to page 20 of those responses.
And just for the record, which document was this when it was filed in EPUC? Which cross exhibit?
So this is cross exhibit D, and it is Morrisville Water and Light's responses to the Adams first set of information requests, which may have been filed in EPUC. I don't recall. I think they were.
Okay. Adams cross exhibit D. Okay. Thank you.
Could you please repeat the question for me?
Is it true that on the exhibit, cross exhibit D, the Morrisville Water and Light's responses to Adams's first set of information requests, March 13th, 2024, under your signature, the company indicated that Morrisville Water and Light has a right under state law to maintain its line, the line in its current location?
That's absolutely what I believe.
That's what's stated in your sworn discovery responses, correct?
That's correct.
And what is the basis for that belief?
My understanding is that there's a state law that was passed that provided for the maintenance of existing lines of this type where there is not clear title to an easement or right of way.
Are you referring to 111A or are you referring to a different statute?
I
I'm
believe
just going to object because it seems like we're getting into legal arguments at this point.
Response?
I mean, I'll rephrase the question, just ask, what was your basis for that statement?
Respectfully,
Basis,
this seems like an issue that could have been dealt with in the discovery process.
I guess my question for you, Mr. Simon, is why does this matter? I mean, let's just imagine that for hypothetical purposes that Mr. Johnstone he's an engineer. He's not a lawyer. And for whatever reason, he's under the mistaken impression that, there's a statute that allows this, but that's not correct. How is this testimony about what his beliefs are going to inform whether there actually is a necessity for the line that crosses your client's property?
It goes to a few issues in the case just because the position has been taken that they have existing rights. It also goes to credibility, but I'm happy to move on.
Okay, yeah, I mean, since you're moving on, I don't know if we need to get into this, but again, Mr. Johnston has mostly offered testimony as, a utility manager and as an engineer. I'm not sure, what his, understanding of the law is, how that really informs us. So, but let's move on and we'll see if this comes up again.
I don't think it will. Also referring you to the exhibit cross D, the Morrisville Water and Lights responses at page 29. Of the request for information. You stated at that time that Morrisville Water and Light solely owned all the poles on the 3329. Is that correct?
yes, I did at that time.
Well, objection only because the way the question is phrased, I believe this is Mr. Heller's testimony or response.
Or I'm sorry. Morrisville Water and Light through Mr. Heller made that response, correct?
That's what
it states on the page, yes.
Excuse me, sorry.
Who said that?
I said that. So I think these questions probably should be directed to Mr. Heller. If you have questions about his discovery responses, Mr. Heller should answer them, not Mr. Johnstone.
Yeah, just give me a moment and I'll get to the next page. You said page 16, please. And do you recall in that document at that Morrisville Water and Light also at that time denied conveying an interest in the line?
Don't know that we denied it. I think that we inadvertently, I was thinking more operationally about how we maintain the line rather than the ownership structure. And I definitely erred in neglecting to raise the ownership share of Johnson, which is 15%. The document has Morrisville make decisions about maintenance. And so for the purposes of my testimony, that's where my head was at. Clearly an error without doubt. And obviously that was corrected along the way.
But that was not corrected in revised discovery responses, was it?
Can you say that again? I didn't understand you again, garbled.
Sorry, that was not corrected by way of revised discovery responses, was it?
I don't recall how it got corrected. I know it got corrected by the addition of Johnson, but unless you can show me a document, I don't remember or recall how that got corrected. So
You never provided supplemental discovery responses, did you?
Objection only that the point has been made and responded to that Johnson was not initially included has subsequently been concluded. I appreciate the impeachment purposes, but this could take a while.
So I think what we're saying, Mr. Long, there wasn't a supplemental discovery response filed, correct?
Not that I'm aware of. Certainly there was the amended petition.
Okay, I think the point's been made. We can move on.
Thank you. And then you acknowledge that the bill of sale that's now in the record, as well as the quitclaim deed that's now in the record, those both indicate that Johnson, as you just said, was conveyed a 15% interest in the line, correct?
Objection. We've covered this territory. If Mr. Simons would like to show Mr. Johnstone an exhibit, I'm certainly happy to allow Mr. Johnstone to discuss it.
Yes, if you are referring to a cross exhibit, that would be, please share it so we can see.
So they were originally cross exhibits, but I'm not treating them as cross exhibits because they are in the record already. So I am referring, I'll put it up on my screen. So exhibit PETEB4 was a bill of sale from Morrisville to Johnson, correct?
Yes, sir.
Okay. Just want to raise an objection to this one. Again, this appears to be related to Eric Bailey's pre-filed testimony, not Scott Johnstone's testimony, and we're asking for the provenance of a legal document.
I haven't actually heard the question yet, so can you repeat the question, please? What's the question, Mr. Simon?
Just isn't it true that Morrisville Water and Light have included in the record the publicly recorded bill of sale PETEB4? That is in the record. You're aware of that bill of sale?
Yeah.
Morrisville Water and Light.
Sure.
If it's helpful, hearing officer, Morrisville Water and Light is willing to stipulate that Johnson is a 15% owner.
Yep. And that this document was filed. Yeah.
Correct.
By virtue of the bill of sale and the quitclaim deed?
I'm not testifying. I'm not sure if you're asking me to follow up on that.
No, I'm just asking if you stipulate that the bill, the 15% ownership is a product of the bill of sale and the quitclaim deed in PET EB5.
Morrisville Water and Light is certainly willing to stipulate that those two exhibits have been filed on its behalf. We're not going to stipulate the legal significance of those documents other than to say that Johnson, to our understanding, is a 15% owner.
Okay, thank you. So the time original, well, strike that. That's answered. So the prior hearing officer or a prior hearing officer ordered Johnson to be included in the petition, correct?
I don't know. I don't recall, sir.
Okay.
I recall this. I recall we added Johnson, but I don't recall how it came to be.
Okay, and the petition was amended after the last evidentiary hearing to include Johnson, correct?
I didn't hear you, sir. It was garbage.
The petition was in fact amended to include Johnson, is all I was saying.
Yes, I believe that's true. That's true.
Right. And the amended petition, or what's titled the first amended petition, putting up on the screen, that acknowledges that paragraphs 1 and 2 that Morrisville and Johnson Water and Light departments are both organized electric utilities, municipal electric utilities, pursuant to 30 V.S.A. Chapter 79, correct?
Objection only to the extent you're asking him to adopt what is stated in the petition. No objection to the extent you're asking him, does the petition say what it says?
No, I'm just asking, that's what the petition says, is that Morrisville Water and Light and Johnson Water and Light are both municipal electric utilities under, among other things, 30 V.S.A. Chapter 79, correct?
That's what the document says, sir.
Thank you. And I'd like you to look with me at your pre-filed rebuttal testimony, which I will pull up before I reshare it. And are you familiar, sitting here today, are you familiar with that pre-filed rebuttal testimony?
I've reviewed it, yes.
A lot of clicks to share. So do you recognize what I have up on the screen now?
You don't have it, you don't have it exploded, so it's very, very small. It's only on like part of the screen. Yeah, I can see it. I can read it now. Thank you.
Of course, I lost it. All right, can we see that?
I can't.
And you agree that that's your pre-filed rebuttal testimony?
Yes, it appears to be.
And would you agree that, so I'm going to go to page 6 of that pre-filed rebuttal testimony. On line 3, the highlighted section, sometime thereafter in approximately 1960, the line and poles in their original position were repurposed to serve as a transmission line. You testified to that, correct?
Yes,
And that answer provides information regarding the history of the line, transmission line that's the subject of this proceeding, correct?
yes, starts in the early 1900s and comes all the way up through.
But you said in your rebuttal testimony, in 1949, the original poles were replaced by the poles that are currently in use, correct?
That's what it says.
And you don't know what was there between approximately 1930 and 1949, do you?
I know there were poles, because there had to be, but beyond that, no, sir.
You don't know what the location of those poles was, do you?
They ran along the same corridor, but I couldn't tell you exactly where they were.
Right. Now, if we look, I'm going to direct your attention now to Adams Cross Exhibit C2. And I'd ask the hearing officer, I think it's appropriate to take judicial notice of this exhibit. It is a group of documents that were filed by the petitioner. There was a petition for declaratory ruling in 2009, as well as a related Vermont Supreme Court case, 2006, as well as a Vermont Supreme Court case and related filings.
Objection for two reasons. One, relevance to the necessity issue before the tribunal today. Second, this appears to be a document containing multiple documents, which is in violation of the PUC's rules on filing separate documents as exhibit.
So regarding that last issue first, it's all one document in the sense that these documents were sent to the Adamses together by the petitioner, I believe. That's my understanding. I have it marked as cross C2, but again, I think that it's appropriate. I don't think I'd have to mark it that way. I think that given that these are in the public record, given that they're court filings and a Supreme Court case, I think they're appropriate for judicial notice.
I don't want to become overly argumentative on this, but that's foundation that's not in the record anywhere. And as the attorneys are certainly aware, things are filed one at a time. Notice of appearance is filed separately from initial brief. It would be separate documents in the court docket as well. So if judicial notice is taken, it needs to be taken as separate documents.
Leaving aside the form question, first of all, when we're talking about judicial notice, Mr. Simon, you're asking that we just take judicial notice that these documents were filed with the commission, or are you asking us to take judicial notice of certain facts or statements in those documents?
So why don't I get at this a slightly different way? Because I think that the substance of what we're trying to talk about here is really just goes to his basis for knowledge of his testimony. And so why don't I just ask you, Mr. Johnson, referring back to your pre-filed rebuttal testimony, in that section that we were just talking about, and it's up on the screen now and it's highlighted, you provide various historical information regarding the line. We were just talking about that. Do you recall that?
Yes, sir.
And you recall in that testimony referencing various documents.
Can you show me it, please?
Well, so for example, what's up on the screen now shows that you are referring to PETSJ REB 8. You see that reference?
I see the reference. Can you show me it? Can you show me REB 8 just so that I know what I'm looking at?
Yep.
If you're going to ask me about it, I want to know what I'm talking about.
Yep. REB 8 is up on the screen now. That's the 1909 to 1910 annual report of the village.
Okay, thank you.
Yeah. So you recall your discussion in your pre-filed rebuttal testimony about that exhibit, and you also discussed in that testimony PTSJ REB 4, the record of agreements to convey. You recall that?
Yes, I do. Yes, thank you.
And isn't it true that this testimony is almost word for word statements that were made by Mr. Mullet in prior filings in 2006 relative to a declaratory judgment action brought by Morrisville Water and Light?
Objection assumes facts that are not in evidence and requires Mr. Johnstone to recall a document he was shown in these proceedings.
I'll strike the question and just ask the more general question. How did you gain your knowledge that you testified to relative to the history of the line in this section, page 5, page 6 of your pre-filed rebuttal testimony?
One of the beautiful things about Morrisville Water and Light is its attention to history. So we have copious records of the entire history of this place since 1895, and we have staff people that are fairly conversant. So as this came about, there was no shortage of historic documents to review, including those original. We still have the original annual reports for almost every year since 1895.
So do you acknowledge that the highlighted sections of text on pages 5 and 6 of your pre-filed rebuttal testimony are not your own words, but those were words that you took from some historical documents at Morrisville Water and Light?
Objection only to the extent it characterizes Mr. Johnstone's testimony.
I think we can just rephrase the question here to just say that is this the basis of Mr. Johnstone's testimony, that the document, that's what you used to get knowledge on this subject?
Yes, it is. I obviously wasn't working at that time.
Well, no, but more importantly, you took that language verbatim from a document written by Mr. Mullet, didn't you?
Objection on relevance at this point.
Well, I mean, to the extent we're trying to get to the basis for Mr. Johnston's testimony, I'm fine with that. Is there an implication here, Mr. Simon, that because he used the same words in the document that it's somehow less reliable, or what's your point here?
Just that it's not his personal knowledge. He's relying on Mr. Mullock's statements as the basis of his testimony.
I'm not really going to accept that premise. I mean, utilities are allowed to, or managers of utilities are allowed to review the records of the company, and I think make statements about what their records indicate. And I don't think that is a particularly surprising point. Obviously, any business is going to look at its records, and I think Mr. Johnston is competent to testify about the records of his company. I don't really see the relevance of what you're getting at here.
I'll move on.
Yeah.
So just let me ask you then, in reference to those two exhibits that we just put up, the PTSJ Rev 4, which are the documents showing that there were arrangements made with landowners, and the annual report that we talked about. You reviewed those documents, and earlier you testified that you've not been able to locate any easements or the like relative to the Adams property. And so my question is, that means that in those two exhibits, there is no evidence of payment or written agreement with a predecessor entitled to the Adamses, correct?
Objection only to the extent I can't follow that question. If there's a way to simplify it, that'd be helpful.
So I'll simplify it. Those two documents do not reference the Adams' predecessors entitled to your knowledge, do they?
I don't know. We have our records. Obviously, properties have changed through subdivision over the arc of time. We have records up and down the entire length from Morrisville to Stowe of payments made. And for whatever reason, it being 1909, formal legal documents were not made and recorded apparently. But so don't know what to tell you beyond that. It's clear that efforts were made to secure a right to install a line. That's what's clear to me.
So to the extent that Morrisville Water and Light has implied in these proceedings that the Adams' predecessors either signed a document or were paid money relative to the installation of this line, there's no evidence to that effect, correct?
I believe that what we've submitted in this record suggests both that the authorization was made to go acquire those, that the rights were acquired and paid for along the entire length of the line, or the superintendent at the time had no right to build the line. And so legally, I mean, none of us were there in 1909. So, but there's a clear record of a process and payment along the length of the line. Do I know, can I prove to you every single property that existed as properties at that time is included? I cannot, but they built the line.
All right. And presumably they did have, I mean, obviously they did have deed records that go back to 1909, correct?
I'm not sure what your question is, sir. Sorry.
If I go in, are you aware that if you go into the Stowe land records, you can find deeds from 1909?
Yes, I understand you can do that in any community. Yes, sir.
All right, and there's been no identification of a predecessor entitled to the Adamses who signed any document granting Morrisville Water and Light any rights.
There's not on any property along the line from that period of time. Again, what we have is receipts. Nothing was recorded.
Right, but you don't have a receipt signed by someone that you've identified as a predecessor entitled to the Adamses, do you?
Objection at this point. I'm not sure what the relevance of this line is. We're talking about necessity today.
Response?
Well, to the extent that the petitioner has indicated and strongly implied that there is some sort of right, I think it's important for the record to be clear that there is no such right. And presumably, in order to proceed under 111A, there has to be no such right. So it's just, there's a contradiction. As Mr. Johnson was just testifying, he's trying to at the one time say that there must have been something that was done, but then they can't identify it. So I think it's important that the petitioner can't have it both ways. They can't both say there's no right and they can proceed under 111A, but then use some phantom belief that there's a right to bolster their position that they should be able to condemn the Adams property. And if you want me to leave that to argument, we can leave that to argument.
Yeah, I think this is more appropriate for briefing. I mean, I guess just to sort of let you know where my head is at, and this isn't a ruling on admissibility or anything like that at this point, but when we're talking about necessity, we're talking about, do we need this line in this particular location to provide safe, reliable, efficient service? And so, the questions are, would there be a better location for the line? Or is this line not being used to provide service and therefore there's no need for a property right? But, we're here because there's no easement recorded in the record, in the land records. That's why we're here today. So your point is taken, Mr. Simon, that there isn't any evidence of such an easement at this point. But I'm not totally sure why we're really going down this hole here. I think this time would be better to look at, like, why do the petitioners need to condemn an easement here out? And if they don't, that let's focus on that. But the historical record stuff, I bring it up in the briefs, but I'm not sure it's really making an impact right now.
I appreciate that.
Yeah.
So you acknowledge that in approximately 1960, 1959, 1960, the line was repurposed to a transmission line, correct?
I think I heard you. Yes, that was in my testimony.
And you also acknowledge that well, strike that, or it was asked and answered. And so when the line was repurposed in 1940 or the early 1950s, there was no CPG required at that time because that construction predated the CPG statute. Is that right? Or is that
Objection. Objection calls for a legal speculation on what the statutes were at the time and also relevance on the necessity issue.
I would draw it. Do you agree that Morrisville Water and Light cleared the trees on the bare hillside, well, that are identified? And I guess maybe first I should ask you to look at the exhibit. Do you recognize what's depicted in cross exhibit EE?
Believe that's the backside of the Adams property. Looking at, I don't know. I believe that I'm assuming we're on the Adams property at this point, looking southerly-ish.
Yeah, and that's one of the poles, one of the Morrisville Water and Light poles that faces out to Maple Street, isn't it?
Yes.
You do recognize that. You've been to that location, haven't you?
I have while the trees were still there. Yes, sir.
All right. And you recognize this as being that location after the trees were removed, correct?
Can you say that again? I'm sorry.
You recognize this location on the Adams property where one of the Morrisville Water and Light poles is located after the trees were removed. You recognize that, correct?
Yes, sir. Yes, sir.
All right. I move Adams Cross Exhibit EE into evidence.
No objection from
objection?
petitioners. No objection.
No objection from the department, I assume?
No objection.
Okay, it's admitted. Adams Cross
So, Mr.
Exhibit EE.
Mr. Johnson, when the first petition was filed, there were trees on that hillside, right?
Correct.
And when the first petition was filed, there was concern that the trees on that hillside were getting close to the wires, wasn't there?
Yes, sir.
And the position was taken in reference to the first petition that the easement was needed in part to clear the trees from those wires, correct?
That's correct.
And Morrisville Water and Light was able to clear the trees without accessing the Adams property, correct?
At the invitation of the property owner.
The neighboring property owner.
Correct.
All right. So the trees that you thought when you filed the first petition, you could only remove if you access the Adams property, you were able to remove by accessing other people's property. Fair to say?
Due to the cooperation of a neighboring property owner, yes.
All right. And you said earlier that you seem to recall that same area prior to the clearing.
Yes.
Strike that. The clearing, Exhibit DD is on the screen. Is that also a picture? Do you recognize that as a picture of the Adams's property in the area where the clearing was made on the neighbor's property, and there's the fence and berm that are depicted on the site plan?
Yes, sir.
And that's also post-clearing, correct?
Correct.
And that fence is within 25 feet of the line, correct?
I believe so, based on my recollection from the site walk.
I move Exhibit DD in evidence.
Any
No
objections?
objection. No objection.
No objection.
All right, Exhibit Cross DD is admitted.
All right, now I'd like to turn your attention, please, to the revised right-of-way and easement that the hearing officer started questioning you about earlier. You recall that?
Yes, sir.
It's exhibit PET SJ sub 1, and it's up on the screen. And you don't have a copy of that, a paper copy of that handy, do you?
No, we brought no documents. We understood we were to look at documents that you put up.
All right, well, I want to make sure you can see what I'm putting up there.
Yep.
Can you see the text of that document?
Yes, sir, I can.
All right. So who is the grantee in the third line of that document?
Looks like Village of Morrisville Water and Light Department.
And in the fourth line, after this language, its successors and assigns, what is the next language there?
It says the exclusive perpetual right and easement to operate, inspect, repair, replace, renew, and maintain above ground cables, lines, and appurtenances herein the facilities for the transmission of electric current upon the strip of the grantor's land in Stowe, Lamoille County.
And that you can stop right there. So Morrisville Water and Light is seeking through this easement an exclusive and perpetual right to operate, inspect, replace, and renew the line, correct?
That's correct, sir.
And isn't it true that the easement grants the right to transmit electrical current with an unspecified voltage, correct?
It's not listed, you're correct.
And in the second paragraph of the easement, isn't it true that the location of the easement is described in that paragraph as not more than 25 feet on either side of the central line of the facilities?
That's what it says.
However, the dimensions of the facilities are not described in the easement, correct?
Could you say that again? I didn't hear you, sir.
The dimension of the facilities or the dimensions are not described in the easement, correct?
I'm not sure what you're referring to by the dimensions. I'm sorry, I'm not quite understanding the question.
So the width, height, circumference of the poles, the width of the cross arms, none of that's described, right?
Certainly, thank you. That helps me. Yeah, no, they are not described. The only thing described is the maximum boundary of the easement.
And the location is described as being 25 from the center line of the facilities, but the actual location of the facilities themselves is not described, correct?
That's correct, and it says shall not be more.
Right. And in fact, based on the easement, there's no description of where the poles are actually located, correct?
Not in the easement document itself, no, sir.
Right. And so the existing facilities themselves are not described in the easement other than what's there in that paragraph, correct?
Yeah, correct, and as is true of all easements we work on, we don't detail out specific GPS locations of the infrastructure.
Sometimes you have a survey map that identifies locations though, don't you?
Very rarely, when we have it, only if there's a new development, we might have that, but even then, not all the time.
And the description of 25-foot strip of land on either side of the center line facilities, that's not limited to the existing location of the facilities. That's wherever the facilities are located, correct?
That's
Objection
why
calls
it's
for a
described.
legal conclusion. We're dealing with, I identify 30 V.S.A. 111 at the bottom and the certain prescriptions related to that, which I think would impact the answer to that question.
I guess what I would ask, maybe I'll try to rephrase the question and see if this is not objectionable. Mr. Johnstone, do you think that this document would allow, that this easement that's described here would allow the companies to move the line within that easement and therefore change the dimensions of the easement?
No, sir, it would not.
But doesn't the easement read literally allow that?
Objection,
No,
this is
because
this argument.
I think that Mr. Simon, what the scope of the easement really is a purely legal question. So I think that's for the briefs. But I mean, I do think it's relevant how the company would, states they interpret it, as is kind of interesting testimony worth having here. But feel free to, when we get to the end of this hearing, I have some points that I'd like discussed in the briefs, and this is one of them, is whether there needs to be any changes to this language to define the scope of the easement more precisely, and I'll be interested in hearing about that. But I'm not sure that the testimony from Mr. Johnstone is going to be really useful at this point.
Mr. Johnson, in that regard, though, do you recall your discussion with the hearing officer when he was asking about this easement?
I'm sorry, sir, I didn't catch that at all.
Do you recall your discussion with the hearing officer when he was asking about this easement?
Are you talking, you're talking about the site visit?
No, earlier when the hearing officer was asking about this easement, you were.
Oh, sorry, I was trying to place, yeah, go ahead.
Yeah, you were providing some interpretations of how Morrisville Water and Light would interpret the easement, right?
Yes.
And you were just providing another interpretation just now of how Morrisville Water and Light would interpret the easement, right?
Yes, sir, based on how we interpret it in all cases.
Right. But just because you interpret it that way doesn't mean that future boards or future executives of the company would also interpret it that way, correct?
Objection, simply ask for speculation, not facts.
Well, I can rephrase it. You can't bind your future predecessor or successors, can you?
I cannot. What I would say to that is if we make any substantial change of any sort in terms of any of the questions that you're asking me, it's no longer normal maintenance of a line and raises questions about other regulatory proceedings at that point. So while I can't bind anybody, all future people in this position have to follow the rules that govern how much latitude we have, and still be considered maintenance of a line.
But you consider maintenance of the line replacing the poles with larger poles.
To meet a current standard only for the same operation and purposes, but within current standards of, in this case, 2026. Yes.
Standards that you're not an electrical engineer to be able to testify to,
I
correct?
am not so. That's correct.
The third paragraph easement seeks the right to enter upon the grantor's land for access to facilities, correct?
Where are you on the document? I'm sorry.
The third paragraph.
I don't know which is the third paragraph, sir. Thank you. That's helpful. Thank you.
That language
read that.
provides.
Yep. Yes, sir. I see it now. Yeah, got it.
That language provides no description of the route that can be used, correct?
That's correct.
And there's no description in the easement as to where entry could be made, correct?
That's correct.
And there's no description in the easement regarding where Marshall Water and Light can or cannot pass over the grantor's property, correct?
That's correct. This is our standard easement document that we start with every property owner.
So I may be mistaken, but I thought that the first easement that was submitted, which is up on the screen as cross exhibit F, I thought that was your standard easement that included underground gates and the like.
Yes, we had modified it some in dialogue to try to get to this, but we had narrowed the width to try to make it more acceptable in this case. But those what I was saying was generally we don't identify the access point. We can if the property owner wants that. This typically comes out in dialogue with the property owner of what's acceptable to them in terms of the means of access. So we're always happy to talk with people about that. What's important in terms of access is we must be able to have it when not only for normal maintenance, like replacing a pole where we can schedule access, but for emergency uses when the poles break in the middle of a storm or wires come down or what have you, when the need for emergency access.
I'm going to cut you off to get a little far from the question, but the bottom line is that this is not your standard easement. It has some elements of your standard easement, but your first easement was your standard easement.
Correct, sir.
All right. And the easement says that same paragraph 3 that entries upon the Adams property can be made for all purposes properly incident to this easement, correct?
I heard half of that, but I think it's correct.
Nothing in the easement describes what purposes might be incident to the easement, does it?
I still didn't hear the last 3 or 4 words. I'm sorry, you're very garbled. Maybe I'm the only one that's getting garbled, but I am.
Turn off both your mic and your quote. I'm gonna try to, can you hear me?
Yes,
Turn off
Yes, I can.
Turn off the light. All right, can somebody say something?
Can you hear us?
Yeah, but hold on. Just turn it all the way down, mute it. All right.
While we're taking
You
this
can
little
hear me,
pause,
I don't know
Mr.
if I can
Simon.
hear you. I'm trying to clear up a problem with Mr. Johnson not being able to hear me. So I'm trying to use the same computer I'm sharing with. All right, go ahead. Hold on. Can someone say something?
Testing. Can you hear us now?
Yes. Mr. Johnson, does that sound better?
sounds much better. Thank you so much.
And
You're
while we're
welcome.
taking this pause, Mr. Simon, I'm just going to let you know you got 10, 15 minutes for planned time at this point. So just want to make sure you stay on schedule.
If you said I'm sorry, I didn't understand that.
You have about 10 to 15 minutes left, at least for the original plan, 75 minutes here. Okay.
Okay. If the easement is granted, Morrisville Water and Light would determine what purposes are properly incident to this easement, correct?
I'm really sorry. You're trailing off at the very end. I'm not getting the last 2 or 3 words because you're not articulating them in a way I can understand them.
If the easement is granted, it would be Morrisville Water and Light's discretion to determine what purposes are properly incident to the easement. Is that correct?
Yes, sir.
The next sentence in the easement says that the easement includes the right to clear and keep clear a right of way not to exceed 25 feet on each side of the facilities of all trees and underbrush by such means that the grantee may select, correct?
That's what it says. Yes, sir.
And it also grants the grantee the right to select and cut down from time to time all dead, weak, leaning, or dangerous trees that may exist outside the right of way but are tall enough to strike the wires in falling, correct?
That's correct.
So the easement does not describe the actual distance from the center line of the facilities where the grantee or its assigns has the right to cut down additional trees, correct?
It does not.
And in the 4th paragraph of the easement, it says that the Adams are prohibited from planting trees or bushes, buildings, structures, or storing lumber or other immobile materials within the right of way, correct?
Is that the paragraph that starts the grantor shall?
Yes, I believe so.
Thank you. Let me read down through that. That's what it says. Yes, sir.
All right, and you're aware that they currently do store lumber and other things within what would be the easement area, correct?
Yes, sir.
And they have a retaining wall and ornamental trees in that area, correct?
Yes.
And the easement also prohibits them from changing the grade, filling, or excavating within the strip of land to be condemned if the grantee believes doing so would interfere with the proper operation and maintenance of the facilities, correct?
That is what it says.
And if the Adamses if the easement were approved, the Adamses would have to keep and clear an area of up to 6 feet from the exposed edges of all above ground structures, as you testified to earlier, correct?
That's what it says. Yes, sir.
And then you have a number of illustrated uses there that would be prohibited, such as swimming pools, tennis courts, buildings or structures, unregistered vehicles, or storage of materials or equipment, right?
Yes, sir.
And it says those are forbidden uses that are illustrative but not exhaustive, correct?
Correct.
So there are other uses that are forbidden but not listed in the easement, correct?
Those were examples. That's correct.
And the final sentence of that fourth paragraph here states that the storage of any vehicles or otherwise within the right of way shall be undertaken at grantor's sole risk and liability, correct?
That's what it says.
And nothing there defines what or otherwise means in that context, correct?
Correct.
And so the easement would absolve Morrisville Water and Light of any liability, correct?
I don't know. I'm not an attorney. I don't know how to read that, respond to that, sir.
All right, thank you. Mr. Johnson, you would acknowledge that none of those restrictions or impediments on the landowners exist now, right?
Just objection, it does call for some legal speculation and also some evidence. It's not necessarily in the record at this point.
I'll rephrase it. This easement has not been signed, right?
Correct.
And it's not yet been ordered to be a condemned easement, correct?
Correct.
So you can't identify any source by which you would currently have the rights that would be granted in the easement, correct?
My pause is because obviously the line exists there. And so, building a building right underneath the line is problematic, and stops our ability to maintain the line. So how that plays out legally, I can't speak to, but that's why I'm pausing. It's, I certainly feel like we have rights to be there and to maintain today, but since 1909, how that all it plays out legally, I just am not capable, but that's my pause, sir.
But you'd agree with me, wouldn't you, that for the past decades and at this time, the landowners are free to plant trees, grade their driveway, do excavation, store vehicles, park vehicles, without Morrisville Water and Light being able to stop them, correct?
Certainly, we work with property owners all the time. Oh, sorry.
Just the same objection to asking for the legal portent.
Oh,
Mr. Simon, do you have a
your hearing
response?
officer. I mean, I think it's a fair question, given that his testimony elsewhere has been that there's almost no impact on the use of land, yet it would seem that he's acknowledging that there is an impact on the use of land. And again, it can be addressed somewhat in argument, but I think it's important to understand, how it is that he can say at the one hand that there's almost no impact on the land, on the use of land, and then also acknowledge that there are all these impacts. It goes to the question of whether or not they meet the requirements of 111A A2.
Yeah, I guess when I'm looking at A2, the question I have is materially alter the degree of land use associated with the presence of the line. Whose land use? The company's land use or the landowner's land use? When I look at this, I'm thinking about the company's land use, that this any property right established in this condemnation proceeding can't authorize the utility to use the land in a way differently than it is. But I'm not sure this is speaking to the restrictions on the Adams use of their property that are proposed in this easement. But I mean, that's not a ruling. That's just what I see right now. So feel free to brief this more.
We'll have to do that because I mean, what 111A seems to pretty clearly be concerned with allowing an existing facility to continue to exist in its present form. And our position is that this easement goes beyond that quite a bit and imposes a lot of, limitations on the Adamses that don't exist now. It's just a limitation on the Adamses is just the mirror image of a right to the company. So, whether it's that material alters their ability to control the land or the Adams' ability to control it, seems to be one and the same issue. But
I guess I'll turn that question around to you, though, is how is the Adams' present storage of lumber on the land associated with the presence of the line? That's what the statute says, the land use associated with the presence of the line.
Right. So
you'll have to explain that to me in the briefs. I don't want to get too deep into the legal weeds right now, but you'll have to.
Yep.
Yeah.
I appreciate that. And we will brief that issue. So directing your attention to the 6th paragraph of that easement, do you see where it says the electric transmission line was installed in 1949?
Oh, there we go. Thank you. Yes, sir. I see it now.
And in your pre-file rebuttal testimony, do you recall stating that in approximately 1960, the line and the poles in their original position were repurposed to serve as a transmission line?
Yes, sir.
So do you know, sitting here today, whether it was 1949 or 1960 when the lines were put in their current position?
Objection only as to relevance.
Response?
Well, I mean, it partly has to do just with the accuracy of the easement, but it also has to do with, the timing of when the line was in place and how long it's been there has been something that the petitioner has sought to prove. So, I think we'd like to know if there is a clear understanding of that fact. I mean, they've even relied on how old the line is as a reason for positions they've taken in the case.
All right, I'll allow the question.
Well, the line was installed around 1909. In 1949, the poles were replaced. And around this 1960 period, the line was repurposed to a sub-transmission line, which is part of the transmission system of the state of Vermont.
So when it was repurposed in 1960, does that mean that it was increased in size?
I could not tell you what one would presume, but I could not tell you. I would presume that's when it went to the 34.5 size, but perhaps Mr. Heller can speak more on that.
Directing your paragraph to the remainder of that section, you see where it indicates that these rights were obtained pursuant to 30 V.S.A. 111A?
Yes, sir.
And then do you see it says these rights to operate, maintain, repair the line shall not, and then it has 3 numbered items, correct?
Yes, it does.
And 1 and 2 are directly, 1 and 3 are directly from 111A, are they not?
I don't know.
Do you know why number 2 in that list does not actually quote 111A?
I do not, sir.
So you'd acknowledge that this language does not include the language that is in 111A relative to materially altering the degree of land use associated with the presence of the line. That language is not here in the easement, correct?
I've not compared the language. You just popped that up very quickly. I can't compare them. So sorry, I can't do that.
I'm putting up 111A A2 highlighted. You see that?
I do, sir.
So you see there's 1, 2, and 3 there, right?
Yep.
And then when you look at the easement, 1 and 2 look the same, or sorry, 1 and 3 look the same, but 2 is different, correct?
It looks like it's been somewhat shortened. I can't speak to why.
It's changed from materially alter the degree of land use associated with the presence of the line or lines to materially alter the capabilities or capacity of the line, correct?
That's what yes, sir. That's what it seems to be.
Now, in some places, the Adams property is not, there's not a full 25 feet from the pole to the border of the Adams property in some locations, correct?
That's correct.
And in those locations, you're not seeking a 25-foot easement from the center of the line, from the line, you're just seeking an easement to the property line, correct?
That's correct.
And
That's
in
what the easement
other,
says.
and in other areas where you operate this line, you do not have a 50-foot wide easement, correct?
But for much of the line, it's in the same current status as the Adams, where we have the same paper trail from 1909 and not a clear easement. In some places, we have different widths of easements that have been acquired over the arc of time through redevelopment of property and other means. But for much of the line, we do not have easements in place of the type we're talking about here.
And ever since you've been at Morrisville Water and Light, this line is operated, correct?
Yes, sir.
And it's operated successfully with minimal interference, correct? Or minimal power outages, correct?
I would not agree with that characterization. This line goes down a lot, and both Velco and GMP are frequently annoyed at us in the winter when this line is blinking and going out as part of the sub-transmission system.
Right. But to be clear, whether or not you have a full 50-foot width of easement along the line has not prevented you from operating the line, correct?
We've been able to operate it, but not with the consistent reliability that a sub-transmission line needs to operate with. Yes, I'll stop there.
Do you recognize T2, the exhibit I'm putting up, cross T2, the easement deed from Dean LLC to the Village of Morrisville Water and Light?
For the record,
Let's
that
see
hasn't
the
been
document.
shared.
I don't see the document yet, sir.
Oh, apologies, sorry.
Sorry.
And while you're doing that, just to let you know, Mr. Simon, we've gone over the 75 minutes. So at this point, if you want to borrow some time from Mr. Bailey's cross, that's fine. But just letting you know that's where we're at.
Yeah, I think Mr. Bailey's cross is going to take about half the time that was allotted. So I would like to take some time from that, please.
Okay.
All right. Do you recognize the tile store easement Adams Cross T2 that I put up?
Can you go to the top so I can see it, please?
Sorry, what's that?
Can I see the top of the document so I know what I'm looking at, please?
Yeah, and I'll just represent that this was provided by Morrisville Water and Light in response to discovery requests.
Yes, I see it's an easement with DNL Enterprises.
And that's where the tile store is located next to Shaw's, correct?
I don't know what's stored there, sir.
All right. That's an easement for the same line that we're talking about in this proceeding, correct?
It is the same line, yes, sir.
And it's one that Morrisville Water and Light negotiated with DNL Enterprises, to your knowledge?
Before my time, I would presume so. I don't know the timing of it. I'm sure you can show me in the document.
So it's dated December of 2018?
2018, yes, sir.
And that's a 25-foot easement, correct?
Correct. So it seems to say.
And that easement is not an exclusive easement, correct?
I don't know. You'll have to show me.
There's just, you can look at it, there's nothing in there that says it's exclusive.
Objection,
I don't
we're
know
showing a
that.
document and we're scrolling around it. I don't know if he's had a chance to review it. And just an objection on relevance as well.
I'll just say, I'm going to ask a different question. I'll withdraw that question. Just to be clear, the fact that you have the 25-foot easement granted by this document does not impair your ability to operate the line, correct?
Makes it more, an easement of that width will make it more difficult for sure. It also depends, and I'd have to go out to this site. It also depends on what type of other access there is. Can we drive from one end right under it? Is there ability to reach across from a parking lot of other types? So there's many factors that can determine what width can be appropriate. And what we try to do, as I've said a few times, is in each case work with the property owner. Most of the time that's quite easy to do, to determine what we can manage the line with successfully in each individual case, working with property owners along the way.
Oh, sorry about that. That's I appreciate that answer, but the bottom line is Morrisville Water and Light was able to negotiate a 25-foot easement and make it work with DNL Enterprises. Isn't that right?
I don't know that I would add to make it work. I'm not sure I would have agreed to a 25-foot easement, but the manager at that time must have determined that that's what he would do.
All right. I'd move exhibit T2 into evidence.
Objection, lacks a foundation of personal knowledge, lacks relevance.
It's a document recorded in the land records, so it's a public document produced by the petitioners.
Public document exception to hearsay requires a certified copy, which this is not.
I'm not.
Do the petitioners acknowledge that this was a document provided in discovery?
I have no issue with making that acknowledgement.
Yeah. Okay, I'm fine with admitting this document. So it's admitted.
For my notes, was that T2?
T2 is in Tom, yes.
Thank you.
Need to find. I'm putting up on the screen another document related to the tile store easement. So I'm showing you Adams Cross Exhibit CC2. Do you recognize the location on page 2, in the picture on page 2 of CC2?
I'd be speculating. I'm guessing that's probably the back of the Shaw's building, but I don't really know.
Right.
It's not
This
a
is
line
the,
I've personally walked.
yeah, this is the area where the tile store easement we're just looking at is located, correct?
Excuse me, could you say that again? I wandered in my brain.
Sorry, this is the area where the tile store easement we were just looking at is located, correct?
I don't know. I don't know each property in that area, sir. Not trying to be unhelpful. I just can't say for sure.
All right. And I can ask Mr. Heller about that document, so thank you. Can you make a note of that? Now, you sponsored the plan by Land Integrity in your testimony, correct?
As required by the hearing officer at that time, yes, sir.
And I'm putting that site plan up on the screen now. Did you participate in preparation of the site plan?
Not at all, sir.
Is it certified by a surveyor?
Can you go to the title block so I can see the stamp?
I don't think there is a stamp. I think that's sort of my point. There's no stamp from surveyor, right?
Objection for a moment. That doesn't appear to be the complete exhibit. Looks like it's cut off.
I'm not sure why.
It may not be oriented correctly. Maybe if you rotate it. I'm just going to really quickly check on my screen because I was also looking at this document earlier today and I didn't have this issue.
I'm gonna try to close it and reopen it.
I mean, this is a little out of order, but if people consent, I'm happy to share my screen, which is a copy of Exhibit PET SJ-2-Sup1, and we can ask questions based on the whole document because that's a
Sure.
cut off image.
Yep.
Okay.
Please, thank you.
No objection at all.
All right, just trying to speed this along.
Thank you. So it's not stamped by the surveyor, is it?
I do not see a stamp on the document.
All right. And so it can't be recorded in the land records, correct?
Objection
don't
calls
know.
for a legal conclusion.
Common knowledge, Your Honor.
Maybe, I don't know. Can you file things in the land records that don't have a stamp on them? Can I file like a Denny's menu if I want?
Not maps. Maps are different, but we'll move on. And
Okay.
the site plan does not identify any other owners in the vicinity of the property, right?
I don't know. I did not review this in great detail. We simply gave the surveyor the instruction from the hearing officer and asked him to produce a map that complied. We didn't review it. It's not our work product. We complied with the hearing officer.
And can we zoom into that document, please?
Which portion would you like to look at closely?
Right where your cursor is,
The
where
sort
green-
of center area?
Yeah, where the green lines come in. So that site plan shows sewer lines coming through the easement area, correct?
I believe it's this line marked E.
Nope, that's another electrical line.
Oh, it's the
green,
SSS.
the green S on the.
Yeah.
So
I
those are
would
sewer
presume that's
lines.
what it is. I'm not looking at the legend, but that would be a typical designation of a sewer. And I'm aware that the town of Stowe has an easement for a sewer line down through there. At least I've been made aware by the town of Stowe. I haven't reviewed that easement myself.
And then whoever these neighboring property owners are, also have private sewer lines that would be condemned by the easement, correct?
Objection
know that they
for
do.
conclusion.
Well, I'll rephrase it first. There's also private sewer lines coming into the easement areas depicted on the site plan, correct?
That's what the map would indicate. Yes, sir.
All right. And Morrisville Water and Light seeks to condemn that area where those sewer lines are located, correct?
For the use of maintaining an electric sub-transmission line. Yes, sir.
And so you'd be condemning an area that's already devoted to a municipal use, correct?
Objection, legal conclusion.
How about you're proposing to condemn the same area?
Yeah, you're proposing to condemn the same area where these municipal uses are located and private sewer lines are located, correct?
Yes, I believe that they can be mutually compatible.
But you don't, for example, you don't know what work the town of Stowe might want to do in the future, and they would have to come to you and get your permission to do that work, correct?
As we would have to compare notes with them in order to make repairs to our poles so that we don't send a pole down through the middle of their sewer line.
And if the private property owners whose sewer lines cross into that easement area want to make improvements or changes in the future, they'd have to get your permission as well, correct?
I think as with any other area, they have, those lines are there. They have a right to be there from my perspective. And so there's always a need to communicate in these cases where you're digging, particularly in a case like this, where you're gonna have a backhoe underneath a power line that could cause death and other harm. You bet we'd want them to talk to us.
But you've not notified any of those private property owners or included them as parties in this condemnation, correct?
Don't believe we're proposing to change their right to be there or their use.
But you're condemning the land over which their sewer line runs, correct?
For the purposes of operating an electric line.
And you'd acknowledge that if they wanted to tear up their lines, they may have to, you may be able to prevent them from doing that if you have your condemned easement, correct?
Just objection calls for legal conclusion again, and again, relevance.
Well, I'm going to ask a different question. Your easement prohibits excavation within the easement area, doesn't it?
Without consultation with us, certainly. So yes, it says that. And obviously, if there's a sewer line there and it's failed or needs to be replaced, as we would with every property owner, we work with people every day on situations like this.
So if they haven't been notified or made parties of these proceedings, how would they know that?
That'd be a
Objection
legal
calls for
question.
legal
I don't know.
conclusion.
I'll ask you a different way. There's no way for those private property owners to know that they have to get your permission if they want to make improvements to their sewer lines, is there?
They'd be required to, if nothing else, they'd be required to file a dig safe, which would notify us, and property owners generally know that, and certainly all contractors know that.
DigSafe doesn't have information to share with the public. They just notify municipalities of a request, and then the municipalities share the information with the public, correct?
That's correct.
Objection assumes facts that are not in evidence.
I think he's trying to elicit some information that, so I'm fine with the question. Let's, I mean, to the extent Mr. Johnstone knows what DigSafe notice DigSafe provides, please let us know what you think about that.
They certainly notify all, not just the municipalities, but all utilities to come and mark out where there are constraints. And so Morrisville Water and Light would always be notified of such a condition. And that's when we would engage both with the property owner and with the contractors to raise safety questions and to make sure that whatever work has to be done can be done in a safe manner that meets the needs of that customer as property owner, as well as the needs of the utilities.
So for those properties owners, that could be the first time they learn of this easement is when they get contacted through DigSafe.
Every one of those property, I believe every one of those property owners is quite well aware of this proceeding, not by Morrisville Water and Light, but we've had a lot of buzz around this proceeding.
Could the hearing officer move the image to the down left so that it shows more of the northerly section?
The northerly section. Right.
Yeah, so that we can see more to the right and to the upper right side there, yeah.
Yeah.
You acknowledge that there's a brook that passes under the proposed easement area, correct?
There's one labeled there from the surveyor, so yes.
And there's been no wetlands assessment to determine if the proposed easement would be within the wetland or wetland buffer, correct?
I don't know. The surveyor did whatever was required by the hearing officer. Morrisville Water and Light, to my knowledge, has never done a wetlands assessment on this property.
And where it says that you can clear vegetation by such means, that would include by herbicide, correct?
Where does that say this on this document? I'm sorry,
No, in
talking
the, I was referring to the easement, where the easement says that you can clear.
Okay. I apologize. I didn't know we were on the easement. I apologize.
Nope.
Presumably we could use herbicide if necessary. And again, we always work with property owners. Morrisville Water and Light does not typically use herbicides. I know that there are others like Valco and others that have a regular program of that. We tend to do things via cutting, not via the application of herbicide. But you would have the right to. You're correct on that. It's not our practice.
And you don't know if that would or would not violate wetlands rules, do you?
There are ways to, with certain types of herbicides, there are some that are designed to be used around water and some that cannot be used around water. And so we would, if we were to do it, we'd have to get the right permits that should they be required, and then apply the correct type and form of the chemical being used.
So just going back again to the town of Stowe sewer lines and the private property sewer lines located within the easement area, would you agree with me that the location of that infrastructure is contrary to the testimony in your pre-filed testimony, page 3, line 16, question 7, where you were asked, does any person or entity other than the landowner have an interest in the property? You responded no, but in fact, the town of Stowe and those other sewer line owners have an interest in the property, don't they?
Yes, we only recently became aware of that with this survey process. We weren't previous to that. I was not aware that there was a sewer line also there. I know when we had the site visit with the previous hearing officer, the issue of certain types of stormwater coming down from the street above came across the property. I don't recall if the issue of a sewer easement was raised or not. I don't remember it, but it could have. But at the time of our pre-filed testimony, I was certainly not aware of the existence of a sewer line.
And then I need to try to wrap this up. So just bear with me here. I'm going to try to go quickly through the last few questions. So the trees are trees that you could remove if the easement's granted, correct?
Yes, sir.
That's all those green dots you could remove?
Yes, sir.
And you could remove trees outside the easement area that are not identified on this map, correct?
That's correct. If they're leaning in and or danger trees and the rest of the requirements that are listed in that easement.
Yet the hearing officer's 11/18/24 order indicated that the site plan should depict any trees and underbrush that would be subject to clearing under the proposal, correct?
But what we have the ability to do directly is what's within the easement. Those outside of it would have, we'd have to be able to explain why we believe that to be a danger tree. I'm not sure any surveyor would know how to identify a danger tree, and that changes over time as a tree ages, becomes unhealthy. So no site plan could really pre-identify what may become a danger tree.
All right. You testified in your direct testimony that failure of the line crossing the Adams property could result in widespread power outages throughout Vermont, correct?
Correct.
And use the word could because you've not performed any quantified reliability analysis tied to those two poles, correct?
That's not specific to the two poles, but we have actually had outages in the region due to this line going down.
Rather than talk about anecdotal instances, there's no written study,
It's
engineering
not
report.
anecdotal, sir. That's not anecdotal. It has happened many times as a result of the wires touching the trees and creating fire and taking the line out, heavy snow touching the trees, and causing the wires to touch the trees and taking the line out. It happens quite frequently, sir.
Yeah, the trees you're able to remove from the neighboring property, right?
And the trees that are directly on this property over time.
You've not brought a written study, engineering report, or Velco analysis that concludes a failure at this location would cause statewide outages, correct?
That's correct, sir.
And your June 2025 testimony states that petitioners do not intend or desire to perform replacements or upgrades that might have an impact on the 248 criteria, correct?
That's correct.
But you do intend to replace the two poles with larger poles, correct?
To meet current standards, yes, but not the use of the corridor in terms of the capacities of the corridor.
Well, you don't currently have any right to use the corridor, so you get all the rights that you get to the corridor would be new rights, correct?
Don't agree with that at all, sir.
Argumentative.
All right, I'll ask a different question. You do intend to use wider cross arms, correct?
To meet current specifications for the use.
And you intend to use taller poles, correct?
To meet current specifications for the use.
And that will actually increase the capacity of the line, whether you tap into that capacity or not, correct?
Most certainly will not. We cannot do that unilaterally without 248 proceedings and much other planning, including going through non-wires alternatives and all sorts of other proceedings.
I'm not asking if you're going to actually increase capacity. I'm saying, or the amount of power going through the line. I'm saying that by making the cross arms wider and the talls higher, or the poles higher, you will have additional unused capacity, correct?
No, we will not. Not in my opinion.
All right. In your discovery responses, you said you had no intention of calling an expert witness, correct?
I'm not, did I say that? Can you show me that in my testimony? I'm not objecting. Not saying I didn't. I don't recall that, sir.
Could I share the screen again, please?
Yes, of course.
And while I'm looking for that, just the opinion you just gave, you've acknowledged you're not an expert in electrical engineering. So the opinion was a lay witness opinion. Is that fair to say?
As a general manager who has experience in the area, I am not a professional electrical engineer, but I have a good working understanding of the electric industry. So no, I'm not our expert.
Do you have enough of an understanding to recognize that when you make poles taller and cross arms wider, you actually increase the ability of electricity to go through the line because it reduces heat and has other capability enhancements?
Objection assumes facts.
I mean, he can answer the question, but Mr. Simon's statement is an evidence, so I'm not worried. If he can testify to that effect, then great. If not, then that's the answer.
So the same wire, the same size wires are going to be on the poles, and it's a 30. We're allowed to operate up to 34.5. We'll be allowed to operate up to 34.5 after that. I don't understand the line of questioning because we're not seeking or gaining any increased operational capability.
Can you currently operate at that level physically?
I couldn't tell you day to day, honestly. I believe we could, but what I would imagine we can. We're designed to be able to do it. The purpose of the higher poles and wider cross arms are not to gain new capability. It's to meet specifications at the time of replacing existing infrastructure, to replace them in kind based on 2026 expectations. Full stop, period.
You don't currently operate at 34.5 kV regularly, do you?
I can't tell. I don't know that. You'll have to ask Mr. Heller that.
Okay. But with these improvements, you would be able to, isn't that right?
I don't believe we're expecting to gain any additional ability to operate that we don't have today, sir. I understand what you're trying to get me to say. I don't agree with you.
All right. And just to go back to that last question regarding experts, if I could share my screen. I'm going to go to page 41 of the Morrisville Water and Light's responses to Adams's first set of information requests. It says here that identify each person whom you may call as an expert at trial to present expert testimony, and your answer was none, correct?
Thank you. Yes, I see that now. Appreciate that.
All right, so there's been no expert disclosed regarding any of these issues having to do with capacity or the like, correct?
Correct, because we're not seeking any.
All right. And there's no expert in electrical engineering, surveying, land use planning, and the like, correct?
We're not seeking any different use of the corridor, so there's no need for experts to prove the existence of therein.
And you've not disclosed any expert to opine as to whether the revised easement would not materially alter the land use, correct?
The current line exists. At the end, there will be a line, the capacity will be the same, so there's functionally no change in land use from our perspective, so there was no need for an expert.
So just, I'm hoping this is my last question, but so at this time, as you sit here today, Morrisville Water and Light has 2 poles and the lines on the Adams property, but nothing more. No corridor. There's no other rights. You just have that infrastructure that exists there today, correct?
You have the infrastructure and the right to maintain it, in my opinion.
In your opinion, and you're not seeking to condemn what exists there now. You're seeking the easement that you've put into evidence, correct?
Objection, I don't understand the question.
Well,
I don't know if Mr. Johnson does.
you could write an easement that just allows you to maintain the infrastructure in its existing location, couldn't you?
I don't know. That's really a legal question. I mean, we
All right,
we
then
moved
if
from
you
our
don't, if you don't
stand.
know, then I don't want to have you talk about it any more than that. But hypothetically, you could keep those poles in their exact size, and as a matter of physics, you could replace them with the exact same poles. And that's not what you're seeking here. You're seeking the right to have larger poles and to have a 50-foot swath on the Adams property that you control, correct?
Objection assumes many facts and speculates as to the engineering.
I mean, I didn't hear necessarily an engineering. I think the question just was the easement you've proposed would allow for a 50-foot wide, up to a 50-foot wide right of way. And also, I think separate from the easement document, you've made this motion for a declaratory ruling that certain upgrades or changes to the line would be within the scope of necessary maintenance. And so I'm fine getting questions about that. This is a slightly different topic though than necessity. And this is something I planned on sort of addressing at the end on the briefing is these two issues do kind of get bound up with each other in that to the extent you're seeking a declaration of certain rights to do maintenance, obviously it makes sense that it would make sense to me at least that maintenance would need to be within the scope of any property right that we could condemn under the statute. And so, you know, there's sort of this question of whether the increase in height to the pole that was described in that motion or the increase in the width of the cross arms is a change. I'm not going to try to quote the statute, but looking at the 3 criteria in section 11A, 1, 2, 3, you know, whether that maintenance would be within the proper scope of that property right. So I think the point that Mr. Simon is just trying to get down here is that the proposal is to have an easement that would allow for some changes to what's on the ground right now. Correct? That's what you're getting at. And then the question that the commission has to answer is: are those changes allowable? You know, are they within the scope of an easement that could be condemned under the statute or not? And so really these are questions of materiality, significance. You know, you guys can point to the record and brief me on why you think the change in height is not significant or it is significant, you know, and that's the sort of determination the commission has to make. So I don't know if you want to try to answer the question or have that repeated to you so that I know I talked a long time. You know, I think we can get at something here, but the way you asked it off was seeking a lot of legal conclusions. And I think really what we're getting at is just what are the facts that, you know, that are relevant here.
So let me make an attempt to answer the question. So what we're seeking is to replace 2 poles and the cross arms in a manner which we believe is consistent with existing operation by only changing the height for the purpose of meeting current standards and for the facility that exists there today. And yes, we're also asking for a 50-foot easement to be put in place to ensure that we have continued access as necessary in the future, which has not been made available to us and has impaired our ability to perform our role and function as part of the sub-transmission system.
All right, thank you. But yet you've also added replace and renew to your easement, right?
I'm sorry, say again, replace
You
and
added,
renew the
you
easement?
add, you added the word, so assuming that 111A gives you the right, that's, to condemn rights limited to that which is required to allow operation, maintenance, and repair of the existing line, you've added to your easement the words replace and renew, correct?
Or replace and renew, the renew piece is perhaps a term of art. We are trying to replace the existing poles and cross arms. So
Right.
yes,
So-
that is what we're seeking.
So you could have instead put in that easement, the language in 111A that says operation, maintenance, and repair. That's possible, right? It's possible to put those words in the easement instead, correct?
I presume so. There's a lot of ways that we could wordsmith the easement, for sure. The document we put in front of you was an attempt to find a way forward, and so yeah, I presume we could pick different words than whatever the words were, replace and renew. Yes.
All right, thank you. Nothing further.
Okay, it's 12:21. I'm sure some people are ready for a break. Mr. Long, do you have significant redirect that you'd like to do, or do you think we could wrap that up before we break for lunch?
I have no redirect at all. So I think
Okay.
we're in good shape. I think we said what, DPS maybe? I don't know if you have any questions.
I don't have any questions now.
Okay, then I would propose we take our lunch right now and return at 1:20 to get started with the next witness. Does that sound good to everyone?
Sounds good. Thank you.
Yes.
Can we leave the Teams open on a computer just, or does it
Yes,
need
just
to
turn
be
your
closed?
camera and your microphone off so that you
Yep.
know no one hears your lunchtime banter.
All right. Thank
All right.
you.
Thank you.
Camera is on, Mr. Simon.
All right, it's 1:20. Is everyone ready to resume?
I believe so. I just ask that Scott Johnstone turn on his camera so we can confirm that everybody's there. And I'll note for the record, we're having trouble changing the name Scott Johnstone to David Heller, but the
Okay.
testimony of David Heller will be from Mr. Heller.
Okay. All right. So with that, that acknowledgement that, the testimony that we're about to see on the screen, at least in the transcript that's being produced right now, because it's being done by AI, is going to indicate that it's Scott Johnstone speaking, but it really will be David Heller. All right. We're going to resume. Just a reminder that we're still recording right now, and we have a transcription being created. So all of this will be posted on the PUC's YouTube channel afterwards, and also be made available to the parties on request. So the next item on our schedule today is the cross-examination of David Heller. So I'll ask the petitioner to call Mr. Heller.
Thank you. I call David Heller.
Mr. Heller, would you raise your right hand, please? Do you swear or affirm under penalty of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I swear.
Thank you.
Could you please confirm for me that you are David Heller?
Yes, I am David Heller.
And Mr. Heller, did you submit pre-filed direct testimony on or about November 15th, 2023 in this case?
I did.
And did you submit supplemental pre-filed direct testimony on or about June 9th, 2025 in this case?
Yes.
And do you adopt that testimony as your testimony today?
I'm sorry, I didn't hear the last part.
And do you adopt that testimony as your testimony today?
Yes.
No further questions on my end?
Okay. I just have a few questions for Mr. Heller before we get started with the cross-examination. Good afternoon, Mr. Heller. My first question for you is just to maybe provide in a succinct single place, because I had a difficult time piecing all of the various pieces of testimony together. Can you tell me what are the current heights of the poles on the property and the widths of the cross arms that exist today, and then give us the heights and widths that are proposed as part of the maintenance you're seeking authorization to conduct, and what's the difference between the two?
Existing pole heights are 40 foot for each of the two poles on the property. The
And
present
just to
cross
clarify,
arm-
is that 40 feet above the ground, or is that the total length of the wood, including some portion that's underground?
the latter, where you have 40 feet total length, a portion of it underground. So the actual height will be an approximate based on the burial depth. And I could figure out what the actual height is for you, but it would still be an approximation.
Okay, well, I think actually that the Adams submitted a survey that measured the actual heights. But okay, so I just wanted to understand.
Yes.
So the length of the wood is 40. Some portion of that is buried underground. Okay, cross arms.
Presently, they are what is referred to as a 2-pin arm, and that width is end to end of the wood is approximately 60 inches. That is not the spacing of the conductor. The spacing of the conductor is somewhat less.
Okay. And now the company has requested a declaration that certain changes to those poles would constitute necessary maintenance. Can you describe what the changes that the company is proposing?
5 extra feet of height on each pole.
And is that 5
And-
extra feet above the ground, or is some portion of that 5 feet underground?
There will be almost 5 feet of extra height above ground. It's going to be a
Almost.
little less.
Okay.
And then the width of the new arm is 10-foot width.
Okay. So that's the first of my questions. My second topic I'd like to get into with you is a little bit of a question about the your company's current practices when it comes to pole inventory and pole maintenance. I assume your company keeps a pole inventory, a list of all the poles it currently has in service.
That's correct. We do.
And is there a standard replacement schedule for poles? Like how long do you leave a pole out there before you say it's time to pull this out?
Well, there is some subjectivity to when a pole gets replaced. It's based on age, visual inspections, and our economic schedule and our actual construction schedule. So,
okay. So if the company had in its inventory a pole that was over 70 years old, it's not automatically that you say we need to replace this. It's based on an assessment of the condition of the pole.
there's always an assessment. It's safe to say that if you've got a pole that's 70 years old, you better be close. It better be on the top of your list for inspections and most likely replacement.
Okay.
Age
And
is a
when the-
major determining factor.
And when the company inspects a pole and discovers that there are potential issues with the pole due to decay or wear or age, what's the process for deciding how and when to replace that pole?
So at the time of the inspection, if there's any deficiencies found, there's supposed to be a report submitted to the supervisor, someone that's in charge of that replacement schedule. And your question again, please.
And then how do you decide when to replace it? What I'm getting at here is sort of what's the timing? You discovered a deficiency. Is this a we need to fix it tomorrow thing, or is this a it's in our hopper, we'll get to it when we get to it?
There is a series of judgments that are made at the time of the inspection. You know, how serious is the deficiency? Is it an immediate replacement? Is it a do we have time? Sometimes we assign different amounts of severity to what we find and classify in a way that we know it's got to get replaced sooner rather than later.
Okay, so turning to the poles at issue in this case, the company's done an inspection, correct?
That's correct.
And based on your experience as a lineman, is it time to replace this pole now, or do we have some time before it needs to be replaced?
Unfortunately, there is not time to replace. It's now is the time.
And why?
Well, for a number of reasons, some of which I've already mentioned, the age for sure, the condition, which the best and most recent inspection that we've had of the property was when we had a site visit with the last hearing officer. And the condition had definitely deteriorated since the last time or the previous time that I had laid eyes on the two poles. We had our line foreman with us at the time, and he actually leaned on the northerly most pole, and it was starting to lean even with the application of his arm pushing on the pole. So that's an indicator that we're losing strength at ground level.
Is there any other information that the commission needs to consider about sort of the reasonableness and necessity of replacing this pole before the conclusion of this case?
So because the pole line is connected one pole to the next, you can have an event a distance away from the two poles that are on the respondent's property. And because of their weakened condition, be impacted by, say, a car hitting the poles 1,000, 1,500 feet away. And they're in that bad a condition that I'd be concerned that shock wave traveling up the conductors from a remote location could impact these poles in a negative way. I'm talking about wires coming off of the insulators or poles even tipping over.
Okay, I have no further questions. Mr. Simon, you can begin your cross-examination.
Thank you. I had to click on some approvals there to do that. Good afternoon, Mr. Heller. I'm Bryce Simon. I represent the Adamses. I don't know that we've met.
Good afternoon, Mr. Simon. Yes, we have on one other occasion, that site visit at the Adams property.
That's right. Thank you. So you were formerly the electric superintendent for Morrisville Water and Light, is that right?
That's right.
And you started there in 1984,
Yes,
became a lineman in 1993,
yes.
and you're not a lawyer, correct?
I am not a lawyer.
And you're not a land surveyor?
Not by trade. No, I was trained as a surveyor in college, but I never went into the profession.
And you're not a current electric superintendent at Morrisville Water and Light, correct?
That's correct.
Just a moment. And you say you have your college education was in surveying. You don't have a background in electrical engineering, do you?
I am not an engineer, but I have a background in electrical. My craft and trade as a lineman, which oftentimes involves working with electrical engineers.
Right.
But I am not an engineer.
Linemen are primarily responsible for the physical work relative to the electrical lines, correct?
I would say that's a very oversimplification of what a lineman is capable of and what he has to know.
All right.
We are highly trained craftspeople.
And the hearing officer just had you describing the specific size of parts of the electrical facility on the Adams property. Are there any other components to it that you haven't described?
I'm not sure I understand your question, Mr. Simons.
So for example, what are the insulators on the poles? What type of insulators?
On the two poles at the Adams's property, they
Yes.
are a two-piece porcelain skirted post insulator rated for a 35 kV class insulation. Circa 1940 something.
And what type of conductor is on the poles?
Well, there's a couple of different ways that they're identified. There's a name for the wire. It's called Linnet, Linnet, but it's the measurement, which is another common way of describing it, is a 336 MCM, 1,000 circular mil aluminum ACSR, which is an acronym for aluminum conductor, steel reinforced. And
that's a 34.5 kilovolt capacity, is that right?
Well, the wire size, you can put any voltage you want to through a wire.
What affects whether you can put more or less?
What it's insulated by, that support insulator, and the wire is secured to that insulator. I mean, if I wanted to put 120 volts through 336 MCM, I can do it.
All right. And are there guy wires attached to the current poles?
No, sir.
Are there any telecommunications infrastructure attached to current poles?
No, there are not.
Have any of the components of the facility been replaced since 1993?
Not to my knowledge on those two poles, no.
Are there other parts of the line that have been replaced since 1993 that you're aware of?
What do you mean when you say the line?
I'll put it this way. You've replaced other poles along the line, correct?
Yes.
You claim strike that. What documents or other evidence has been submitted to support the statement that the current poles were installed in 1949?
What other documents other than what's on record?
Well, even what's on record, what supports, to the extent you believe that the poles were installed, the current poles on the Adams property were installed in 1949, why do you believe that?
So there's our plant records, which contain a bunch of information, of which one piece of data is the age. Poles have a birthmark on them. When they stand the test of time, can be deciphered to see what year the poles were installed. Those are two items that I could speak to pretty quickly off the top of my head.
But doesn't the birthmark refer to the date the pole was created, not the day it was put into service?
That's true.
And when you worked at Morrisville Water and Light, you reported for a period of time to Craig Mayette, the general manager there at the time, right?
Did I report to Craig Mayette?
Yeah.
For part of my career as the working foreman and the electric superintendent, yes.
And are you familiar with the order approving the financial arrangements between Johnson and Morrisville?
That was a little out of my bailiwick, but I'm familiar with it.
All right. Hold on a moment. I'm going to pull up a document. I'm putting up on the screen PETEB2. Do you recognize that as being